topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show. This is going to be probably one of our finest shows. This show today, we have gotten inundated by your emails wondering about the new HOA and condo laws that the governor has signed off on. There's still a lot of them he hasn't signed off on. And we've got the perfect person to explain that to you. This is an attorney and we've got so many attorneys that we do shows with, but this one is one of my favorites. We can now call him board certified, Alan Swartseed. Hi, Alan.
Hi, Steve. Thanks for having me. I appreciate it.
Congratulations.
Thank you. It's been a long road, but we're there.
It is a big deal to call yourself board certified. A lot of people don't know that. How many board certified attorneys are there, in community association law?
I don't know the exact figure, but I'm pretty sure it's less than 250 throughout the state. That's the last figure I heard, was that it was just over 200. And there were only, I believe, 6 out of the 15 that took the exam this year that passed the exam and were treated as board certified attorneys by the Florida Bar. So I'm one of 8 within the firm that's board certified in this area of law now. It makes me very happy to say that. We've got one other that's board certified in construction law. So we've got, everything covered with people that the Florida Bar thinks are good enough and know enough to be qualified as experts in this field.
Well, we're so proud of you. Seriously, I have another board certified attorney locally here in family law. And boy, she has just explained to me what a huge deal it is to be board certified. So congratulations, you deserve it.
Thank you.
Our listeners just love hearing how you explain everything. Tell people, because we have always got, Alan, so many new people tuning in, finding the show. Tell people about K. Bender Rimbaugh.
Sure. Well, as I kind of mentioned a little bit, we are a law firm based in Pompano Beach, which is South Florida. We've got offices in Pompano as well as Palm Beach Gardens. I personally manage the Orlando office of the firm, and Kirsten, who is usually on the show for the Tampa market, is managing the Tampa office of the firm. And I just think we do work that is different and, in my opinion, better than most other firms in this area of law. We try and, like you've mentioned, Steve, even already today, keep things pretty straightforward. There's not a lot of legalese in the way that we explain things to our clients. We just try and explain it in a way that you're actually getting value out of and understanding what we're saying. Representing community associations is all we've done since the 1990s. I haven't been there that long, but since I rejoined the firm in 2022, I'm very proud to be part of this firm. I think, again, we do an excellent job of explaining things in a straightforward way, which not a lot of firms do. They're going to put the answer at the end of their communication so that you have to read through 5 pages of crap you don't care about to try and get the answer you asked for. We're going to make sure that that answer is right up front. And then we'll add the analysis to the extent we think it's necessary to explain the opinions that we're giving you. So I mentioned the attorneys we've got. We've got 20 attorneys, all focus on this area of law. We've got separate departments for litigation, for collection. All that's run out of South Florida, but our Orlando and Tampa offices are local to all of you that are probably listening right now. If you have any questions, you're not satisfied with your current counsel, or frankly, you just need a second opinion on something, you're welcome to reach out to me or Kirsten anytime.
Well, I got to tell you, I'm going to start off the show today. And by the way, I want people to know the K Bender Rimbomb show that we do. We have it broken down into Tampa, Orlando, South Florida is our number one show of all of our shows. We more people calling and emailing, and there's only one of me, so I have to host the show. So we have kind of pulled back from doing the chat line. People still email us, so I'm going to have to ask not to do the chat line and just email us. We're going to get started. Alan, tell us about the new laws that the governor has signed. Everybody wants to know.
Well, I mean, the good and bad news is that most of what was kind of pending has been resolved as of now. Most of it got approved. And I will tell you, if you wanted me to go through everything that's changed, I literally did a class for an hour for a management firm today, and we weren't able to get through everything. So, I'm happy to answer individual questions, but I could do a 2-hour seminar, which we usually do every year and probably will within the next few months. But I could do 2 hours just to talk about the changes that came out this year. Some of them are great, some of them are horrendous, and some of them are somewhere in the middle is what I'll put out there for now.
You know what I'm going to do, Alan? I'm going to go through. We've got so many emails and text messages. There are ones like, here is Jack in Tampa. And I've got some that actually talk about the bill. He wants to know, can you discuss House Bill 293 regarding adopting hurricane specifications? Can you tell us about that, Bill?
Yeah, I mean, it's essentially, that adopting hurricane specifications is exactly what it is. Now, let me be clear. This is an HOA bill. So if you're in a condo or a co-op, ignore this. But if you're in an HOA governed by Chapter 720 of the Florida statutes, what this law did was essentially require that the association adopt specifications, just like all your other architectural requirements and restrictions and your criteria, whatever you want to call it. You have to adopt actual specifications of what you will and won't allow within your community and what people should be using for hurricane protection, whether that's shutters, whether it's hurricane resistant or hurricane proof glass, things of that nature. But it basically says the association actually has to tell people what they're allowed to have. There are limitations on what you can say no to within these policies that you're required to adopt. And that's pretty much what it comes down to is the law now says we're in Florida, wake the heck up. You need to tell people what they are and are not allowed to do to protect their property from a hurricane. Now, again, this is HOA specific. So we're not talking about a building-wide change in a condo. We're talking about, is everything going to look the same throughout your community? Or are you going to have 30 different types of shutters? So this actually makes a lot of sense to me. If you're allowed to have architectural criteria, although the legislature is basically telling us that we can't enforce much of it anymore, if you got that architectural criteria, I hate to be blunt, but just slap this on now. Add these shutter restrictions or hurricane protection restrictions to your architectural criteria. This is something the board gets to decide on. You just need a 14-day notice to the members. And then you can add this to your criteria so that when people are trying to get these hurricane-proof windows, add hurricane shutters to their property, they should know what they are and are not allowed to do. That's the whole purpose of having architectural criteria, is letting people know in advance this should be allowed in our community. So that's really what the bill says, is the association needs to adopt this. Now, here's the issue. It became effective once it was signed on May 28th. So you were supposed to retroactively have these specifications somehow. So my suggestion would be get on this as soon as possible if you're on an HOA board, to try and create these criteria so that you are in compliance with the law. Because if not, if you don't have these specifications, these criteria, you might be stuck with an owner putting something on their property that you really don't want to protect their lot from a hurricane. So that's a lot of words to say. You got to have something in writing that says what you can and can't do.
I should have probably asked this first. Give me your feelings on the bills that were passed. What bills that you like, which ones you don't like?
I like the education bill, which requires community managers to take certain educational classes, or at least a certain number, unless they've been practicing for 10 years already and don't have a disciplinary history. I don't like the fact that people that have been practicing 10 years don't have to do that anymore, because like the legislative update I gave today, attending radio shows and seminars and things of that nature is what keeps them up to date. So I don't care if you've been practicing 10 years. Once you hit another 10, I promise you the laws are going to be completely different. So I don't really like the fact that that was pulled out, but there's a sunset on it for 18 months from now. So hopefully when that sunset hits, the legislature will say, yeah, this was a really bad idea. The other educational requirement is for board members. I think that's a great idea. You've got people that in some instances are managing multiple millions of dollars, but they're volunteers that have no experience with a business. So I think it's a good idea to say you have to actually take a major class and you have ongoing educational requirements, including the same reasons that managers should be required to do that. Some of the stuff that I really don't like is the no violations for trucks being parked in a community where they've been prohibited for the last 55 years since the community was created.
We got letters on that.
Yeah, I mean, the bottom line is, listen, I don't have a preference whether you allow them or not. What angers me is that the legislature is telling us this contract that you've had in place with your members, which is your declaration for the last 50 plus years. And I do represent, maybe I should add more coffee. I do represent several communities that are that old in Central Florida. You've got a 50, 60-year-old community that's suddenly being told, yeah, I know you were allowed to enforce that since the beginning of time, but now the legislature is going to say no. It's the same as the law that came out last year that basically said anything that is installed, displayed, or there's one other word and I can't remember what it is right now, but anything that's in the backyard isn't visible from the frontage of the lot or an adjacent lot, you can't enforce. I don't think that makes any sense. I think it's completely unconstitutional in most instances. The problem is no one's going to want to fight that up to the Florida Supreme Court. So there were additional things that were done this year. The other one was, the commercial vehicle restrictions that were basically taken away unless it's an actual commercial vehicle under the statute. I think that's absurd. The same reason. Yes. Same thing with the, you have to allow people to leave their trash cans out for 24 hours before and after the trash was supposed to be picked up. So now we're allowing people 2 out of every 7 days, presuming that you're not picking up more than once a week. If you're picking up twice a week, you're now saying at least 4 out of every 7 days, they can leave their trash cans out and there's no repercussions whatsoever. That makes no sense to me. Okay, well, why don't we just leave it sitting at the front of the driveway permanently and just toss the trash bags in when we're done with them? It just makes no sense to me that the legislature thinks that's okay. But the bottom line is that in reality, what we are seeing is the legislature basically disliking and disfavoring homeowners associations, condo associations, and co-ops. They're basically saying that these communities have too much power, and it's all based on what 1% or less of the community association boards have been doing over the last decade or so. It's the same thing as when they criminalized kickbacks in Miami in 2017 or 18 in condos, because there was rampant kickbacks going on in the community. It was already illegal. It was already a conflict of interest, but now we have to make it a crime. And I don't necessarily disagree that it should be. What I have a problem with is you're regulating the 1% of instances instead of looking at how you're impacting community associations. And I know that there are many legislators that don't even remotely think about how their actions and the things that they're doing might negatively impact communities. They're looking at, well, people don't like the Karens that are in a community association. They don't like the condo commandos. So I look like a king or a queen or whatever I call myself if I fight these people, even though they're doing nothing wrong. So I'm going to jump off my soapbox now, but I'll put it this way. There's not a lot in the bills that passed this year or were proposed this year that I actually like. The educational reforms for condos and HOAs, I think, are the major benefits that came out of this legislative session, because it really was necessary for people to understand how to run a community if they've never done it before, and they're not required to have any real education other than signing a piece of paper that says, I read the governing documents, I'll do my best.
Let me, we're going to be getting to your schedule, this upcoming schedule. But first, let me go. If an insurance claim involving hurricane damage and cancellation of insurance has been settled, would the condo association be required to show the settlement documents to an owner if requested?
I mean, yes, it's a presuming that settlement involves the association as a party, that becomes an official record. And I'm not aware of any basis to say that that's a privileged document. If the lawsuit is settled, the insurance company is not coming back on you later. So the reality is there's no reason for attorney-client privilege to hold over if the matter has truly been fully settled. Now, that means all the payouts that are required are done, the case has been dismissed, etc. There's literally nothing left to dispute or litigate. But generally speaking, I don't see a basis to hold that document back, although, it just depends on the circumstances.
And we're going to take our first break. When we come back,
Okay.
Let's go over the schedule.
Sure.
There's only only one day left in June on the schedule. The rest of them are July. But you've got a lot of free courses you're going to be offering, and people love hearing about those. So we're going to go to break. When we come back, we have more with Kay Bender-Rimbaum. We'll be right back.
Kay Bender-Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kay Bender-Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kay Bender-Rimbaum is also a well-known provider of free legal education for managers and board members. Contact Kay Bender-Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. I'm your host, Steve-O. One of the things I love that Kay Bender-Rimbaum does is they offer so many courses every month, free courses, and they give so much of their time to education. Tell us what the schedule looks like for, I guess, June 28th through July.
Well, I'm sure that there's going to be more added because, shockingly enough, there's only about 5 of these between now and the end of July. But I will be teaching a condominium board member certification class on Zoom on June 28th at 10 a.m. And all of these, by the way, anyone that wants to sign up, register, whatever you want to call it, that's all going to be on our website at kbrlegal.com under the calendar. July 11th at noon, we've got the importance of updating your governing documents. We've got July 12th at 10 a.m., Community Association Legislative Update. July 24th at 11 a.m., legislative update for condos in particular. And then July 25th, I'm back at 11:30 a.m. teaching a class about fair housing, assistance animals, and service animals, or is that just a pet and someone is full of crap when they tell you that that's their emotional support animal? So that's what we've got on the calendar as of now. I believe there are a couple more live classes taking place, but since those are in South Florida, I don't want to waste the Tampa market's time.
Okay. And by the way, this is our Tampa show. Alan normally does the Orlando show, which will be this Thursday at 5 o'clock. So in case you're not used to seeing Alan on this Tuesday, let's go to, do you know what Bill 1203 is, Alan?
Oh, I do, unfortunately. It is one of the other House bills. It talks about primarily community association managers. There's a lot that this changed. One of the things that it changed is what I mentioned earlier, the coursework requirements and things like that. It requires that the CAM attend at least one meeting of the board every year. There's also now, if the association has a website and includes information anywhere, it's got to include the contact information, what the responsibilities are, and a bunch of other information about the CAM. And when I say CAM, that's Community Association Manager, the people that manage Florida condos, HOAs, and co-ops. The contract for the CAM needs to be made available upon request to the individual member by the CAM. So that's not just a records inspection request. It's here you go, here's an email. So there's a lot of changes, but those are the primary ones. It's, you need to post the information regarding the CAM on your website. You need to give information about who people are supposed to be contacting. And allegedly that's going to help somehow with having people know who to reach out to, because my perspective is if you already had to have a website or you already had a website, you could probably have you probably knew who you were supposed to contact from that website, but this makes it something that's kind of, I won't say front page news, but it makes it a little clearer as to who am I supposed to be contacting and how if I have a problem in this community.
Let's go to Rex in Clearwater. Bill 59. Well, these people all know their bills. Passed before October 1st. Provides physical or digital rules to everyone in the association, condo and HOA. If rules are amended, the association has to supply everyone with the amended rules. Can you give us more detail?
I don't know what more detail I could provide than what you already did. In reality, you have until October 1st, 2024 to provide either each member gets a copy of your governing documents with rules and regulations, or my preference is put it up on a website if you've got one and just tell people, hey, you can find it on the website. You can just send a notice just like you would send notice of any meeting and essentially say, hey, you've got the opportunity to take a look at these on the website. We're not going to mail out copies because that would cost us thousands of dollars, but here they are, have at it. If you've got problems accessing these documents, let us know, but that's pretty much it. I mean, what the individual described is pretty accurate to what is required under this law.
We've got very smart listeners and viewers, Alan. They keep up with this.
Absolutely. Well, what's interesting, Steve, is when you talk about that compiled set, or at least a full set of all the governing documents, that's the first thing we do when we bring on a new client, is compile all their governing documents, put it all together in a bookmark PDF. At least this is what I do from the Orlando office. Put it together in a bookmark PDF and email them a download link. So if you're working with my office, and I've actually, since this passed, I've had several people reach out to me to work with our firm just to get their governing documents compiled the way I normally do it, because then they're just going to say, this is on the website. You can download what Alan provided to us. I'm not suggesting that everyone needs to do that, but it's just an added benefit of working with our firm, is that the initial charge is for me to pull everything together and get it over to you.
Says, I see under the new laws, members can enroll in electronic voting via email. Will there be
Correct.
any administrative rules regarding the specific requirements? Same for approved electronic communications.
Ask the DBPR. There's nothing in the statute, there's nothing in the bill that's an administrative rule as to how you do that. The only added rule is if someone enrolls and opts into electronic voting, then you have to allow them to vote that way until they opt out. What that means for practical purposes is even if you stop using electronic voting, you might not really be able to stop once you start. Now, I don't know of any community that's going to say this is not worth it, we're not doing it anymore. But just understand, once someone opts into electronic voting after you've got your board resolution and you've had your meeting 14 days before the actual meeting, et cetera, and you've allowed people to opt in, whether it's on paper or electronically, to electronic voting, you got to allow them to vote that way indefinitely until they opt out. So that is the one administrative change beyond what, Steve, you already mentioned, that I think is important to note, at least with respect to electronic voting. Now, I won't get into all the changes or the clarifications regarding what constitutes election fraud under the new statutes, but that's a different animal.
Larry in Sarasota wants to know, my community doesn't have any amenities. What are my assessments for?
A lot of administrative crap is really the answer. You've got probably insurance for property that's common area, even if it's just, your roads that the association owns and has to make sure that if people get hurt, you're covered so that that's insured. I mean, I live in a community of 12 lots, 11 of which are actually built out. We have zero amenities whatsoever, but we pay for insurance every year and we pay for a manager to insure and take care of our community every year. We've got zero amenities whatsoever, but I still pay an assessment of like $1,200 a quarter. So that's really this type of thing that you're probably looking at. Even if you've got no amenities whatsoever, you still have maintenance obligations that the association has. You still have your board, you still have your attorneys, because, even if you've got no amenities, you've got the potential for violations to happen that you need to deal with. You've got your assessments being collected, which you need to deal with. So there are still things, even though they're not amenities that you feel you benefit from, there's still a benefit to being part of a community association. And if you don't like that, there's plenty of property in Florida that's not in one.
Here's Mark, and never heard of this town, Valrico. What are the responsibilities of being a board member? That's a good
You
question.
got 4 hours? Because like I said, that's what the class is about to start taking. That's the reality.
Exactly.
There are many responsibilities of being a director. The most important one, in my opinion, is the fiduciary responsibility to do what you reasonably believe to be in the best interest of the association. In other words, you put the corporation before your own interests. So even if something hurts you personally, you've got a legal obligation as a director or an officer of that corporation to do what's in the corporation's best interest. I can't think of any obligation that's more important than that. Now, that's the starting point. You also should, in my opinion, know what the heck you're doing if you're running a business, which in reality, whether that business is for profit or not, that's what you're doing when you run an HOA or a condo. You're running a business. So I'm sorry that I can't give you a little bit more detail, but again, I've got an entire condominium board certification class coming up in a couple days. If you're in a condo, you're welcome to attend it, because that's where you get your answer. That 2.5 hour class is just a taste of what your responsibilities really are as an HOA or a condo director or officer.
How will not having Kaufman language affect the association concerning the new laws?
So, just for people that are not law nerds like me, Kaufman language is essentially that language in your declaration that says that your documents, your declaration of covenants, your declaration of condo, whatever it's called, incorporate changes in the statute. And the way that it'll be worded, if it's there, is going to say, we are incorporating the Condominium Act, the HOA Act. Here's the important language: as amended from time to time. Okay, if it's as amended, that's still not good enough to be Kaufman language. It's got to be as amended from time to time. Okay, what that language does is incorporate all of the changes in the statute, regardless of that argument I presented earlier that you've already got a contract as in the form of your declaration that's existed for 50, 60 years. If you've got that language in there, then the new statutes will apply no matter what the situation is. If you don't have that language, then generally any substantive change in your rights, so like I said, your right to enforce your covenants, in my opinion, is a purely substantive right versus a procedural right, which is here's how you vote for things. Okay, but if the statute changes the right, for example, to tell someone they can't park a truck in their driveway or can't park a vehicle that's completely wrapped in a commercial format in their driveway, and the legislature says you can't do that, if you don't have Kaufman language, technically that statute, in my opinion, shouldn't apply, because that is an unconstitutional restraint on your existing contract, your declaration. It's the government telling you you can no longer enforce your 50-year-old contract. But if it's a procedural change, then it won't matter. So the analysis of whether Kaufman language means anything is something really you should be taking to your attorney. But it does make a difference, yes or no, as to whether you've even got the arguments that I've been presenting. That's why I said earlier, well, there are things that need to be considered when you're deciding whether to try and argue this is unconstitutional. That's 100% something you need to discuss with your attorney. But it will factor into the whether you've got the Kaufman language or not will factor into a lot of the changes that were made this year.
Can an HOA invest reserves in anything other than CDs?
I don't think it's safe to do that, but I don't know offhand whether it is against any federal or Florida law. I know that you can invest to some extent. I know there were changes that were proposed last year that didn't pass to allow you to invest it in a certain manner. And frankly, because of all the changes this year, I don't even remember what was really discussed last year as to the specific context. But I'm not aware of anything that says you can't. I would suggest that you get an actual written opinion from your attorney before you make a decision to try and invest those funds anywhere other than a bank account or a CD, which is definitely allowed.
Alan, we have gotten so many emails, people talking about funding reserves. Not real happy about it. Can you explain to people why this is so important?
Well, here's the thing. So this all stems from the building collapse in Surfside, Florida, a couple of years ago. All these laws are the result of a reaction to that collapse. And yes, it is very important that you have proper reserves and you put the money away that is reasonably necessary to make sure that the structure of your building is being taken care of. The thing is, if it were really an issue, do you think it would take from the 1970s until the 1990s, the 2010s, the 2020s for there to be a problem with a building? From my perspective, the reason that it's important is to make sure that you don't have that happen again. My problem is that wasn't necessarily even the cause of the building collapsing. It was a construction defect. So if that defect exists and all you're doing is going in and checking visibly whether there's a problem, and you don't see a problem as the engineer, architect, or team that's working under one of those that's doing that visible inspection, is that enough to prevent this? Is putting money away for future repairs enough to prevent it? I don't see how it is. It is important to have that money so that you're not sitting there and constantly saying, like the building in Surfside did, the condo in Surfside did, you're not constantly saying, well, we'll deal with it next year. We'll deal with it next year. We'll deal with it next year. And then all of a sudden, a $100,000 project costs you $10 million because you let it deteriorate to the point where it's a replacement, not a repair. But I don't think that this is necessarily the best fix, but it's the one that's been pushed so hard by the legislature that I feel like they can't back down now because they can't admit that they were wrong about, one, the cause of the problem in the first place. Meanwhile, they're making it more difficult to bring a construction defect claim while telling us we got to put this money aside that won't prevent the problem. So I do think it's important to put the money away, make sure you can take care of your building. And by the way, putting the money away doesn't mean that you just have it sitting there. You take care of your building with the money that's intended for these reserve assets. But I don't think just having the money available will prevent the problems that we've seen. Frankly, it puts more money into the hands of the people that they're complaining about down in South Florida that have been stealing that money. And from my perspective, that's a lot of what they're doing. It's also going to put a lot of people out of their condos, out of their co-ops, who can't afford a $50,000 increase for a structural integrity reserve study and a milestone inspection report before you even start putting the money away. So I don't think this is the best way to do it, but sure, reserves are super important. My perspective is if you're doing it right, you shouldn't need them in the first place. You should be budgeting so that you're taking care of your buildings and taking care of all your common areas. If you're not doing it that way, then yes, reserves will put that money away and you'll be forced not to spend it on landscaping instead of your building. That's great. I like that part. But that really, from my perspective, is the reason that reserves are important, is to make sure that the money can't be spent on something else when you're going to need it 3 years from now, 10 years from now for an important aspect of what you're doing.
I had a friend that I know that loves your show. And he said, ask Alan this. He lives in a very large community. They are taking up the entire grass for the golf course and putting in new grass. And he said, with the way the economy is and all the assessments, why would they do something like that now?
Part of it is to stay competitive. I know my parents live in a country club in Boynton Beach, and they're completely redoing 1.5 golf courses out of the 3 that are in the community. Why would you do that now? To make sure that people are actually willing to buy in your community and it doesn't look like crap. I don't know for your friend's community in particular whether the grass actually needed to be replaced. I would hope that it's for the purpose of saying, look at this beautiful community we live in, despite the financial day and age we're in, and the fact that most people are having problems. Our community is thriving. Look at how beautiful and manicured the landscaping is. Look how we take care of this community for the assessments that you're paying. So that, from my perspective, listen, I don't know what the specific reasons were. It could have been a problem that no one knew about because there's not enough communication that the board is presenting to the members and telling them what the reason was. But you know what? That's why you go to board meetings. You go to member meetings. You ask the questions. The board might not be willing to answer them during a meeting if it's not on the agenda. But if you send something in advance and say, hey, can we add this to the agenda so that we understand it better? Maybe they'll be willing to. But if you don't ask the question and all you do is complain, it's kind of hard to make anything change or to understand anything any better.
It's funny because my friend lives in Boynton, so it might even be the same property. I think he was explaining to me that they're putting in a new technology grass that has a GPS on it or something. So, but that was the whole reason. But it's a new, I guess, a new, not a new board, but a new property manager. And he said, I wonder if they're trying to impress people by doing this, but the timing was so bad.
Yeah, I mean, it may be that they're trying to impress people, whether it's the property manager presenting this as an option to the board, or the board trying to impress people and saying, hey, come on and buy in our community, increase our property values by continuing to purchase lots in the community so that the outdated values that frankly can't be used as comparable purchases when an appraisal comes in. If you've got recent purchases, unless they're formerly foreclosed lots, chances are your property values start to go up. So that might be one of the reasons. I can't say in particular. I agree the timing's not ideal, but that doesn't mean you stop maintaining your community just because the economy looks not great. I mean, you still have a legal obligation. You still have, as a board, that fiduciary responsibility to keep maintaining the property and keep it looking good, even if it's tough for people to pay for the cost of that. So I don't know if there was a problem with the grass or if it's just an upgrade, but bottom line, yeah, I don't think it's inappropriate, even though it's not ideal.
We just had somebody call us. They want to know, don't a lot of the property managers also sell real estate? And isn't that a conflict of interest?
Well, I mean, some do. Most, when you say property managers selling real estate, you got to distinguish between a property manager that rents out properties, keeps them clean, etc., versus a community association manager that is working with your community. Now, if you're talking about a community association manager that also sells real estate within the community, yeah, maybe there's a conflict of interest there, but unless they're getting preferential treatment by virtue of being the CAM, where is the problem? As long as they disclose that that they're working as the real estate agent and the board votes on it to say, yes, this is okay, I don't see why it's a problem for someone in the community to be selling, unless there's a situation that causes it to be problematic. If you've got someone that is a difficult member of the community and they're trying to sell a property lower than value to get this person to leave because their property value will diminish, maybe you've got an issue there. But for most situations, I don't see it as a major concern for even a CAM to be a real estate agent that's also selling property in the community, as long as that conflict is disclosed to the board and, to the extent necessary, disclosed to all the members.
Lenny in Plant City, can an HOA combine the original rules and regulations along with new amendments into one document rather than having two separate documents, original and amendment separate?
Please, for the love of God, do. That's my answer. When I come across a new client of ours, like I said, the first thing I do whenever someone decides to work with our firm through the Orlando office is pull their governing documents. And anytime I see that someone's got a declaration and 6 amendments and never did an amended and restated declaration, never did what's called a consolidation, which is exactly what you're talking about here, it drives me nuts. So the first thing I suggest when I see that, when I'm sending over the governing documents to this new client is, hey, if you'd like, the board alone, without a member vote, can approve consolidating these documents so that it, and Steve, it's exactly what you described. It's basically taking the original and all the amendments, putting them together into one document that incorporates all those amendments so that you only have to review one declaration, which I call a consolidated declaration, rather than reviewing 7, 8 different documents. I've got one client that's got 11 amendments and doesn't want to consolidate. So every time I do a legal analysis for them, it costs them more money because I've got to look at all those amendments to make sure nothing that they changed impacts the analysis that I'm doing. So even though this consolidation might cost a little bit of money up front, 1, yes, it's absolutely an option. And 2, it'll save you money in the long run for anyone that's reviewing all of these, the declaration, including your members, your CAM, your board, when they're trying to look at issues, they only have to look at one document instead of, 10 to 15.
This will be the last question tonight. House Bill 1203 for HOAs now has restrictions on what an ARC can and cannot permit on a homeowner's property. But having it viewed from across the lake or a fairway is absurd. It could be 100 yards away.
I'm not sure whether that was a complaint or a question, but from my perspective,
Sounds like a complaint.
Yeah, I mean, I get that, seeing it from 100 yards away, I don't know if you're saying to the person that wrote this, I don't know if they're saying that it's absurd that the association can pursue something that's visible from 100 yards away, or that it makes perfect sense, which is my opinion, that if I can see this problem from 100 yards away, it should be enforceable. I don't know which you were saying, but my perspective is that the changes that were made to that portion of the statute are beneficial for associations. They're beneficial for your neighbors. And yes, you are correct in saying that in addition to what was changed last year, that you could only enforce if it was visible from the frontage of the lot or from an adjacent lot. Now the statute of this year adds it's visible if it's visible from a common area of the association or an adjacent golf course, it's now enforceable as well. I think that makes perfect sense, because why should I be able to enforce it if my neighbor can see it? But if we're across a lake, like you mentioned, Steve, suddenly the association can't do anything about it. The neighbor is still seeing it. There's just a lake in between. It's still just as obnoxious. The bottom line is, if it's visible from outside of the lot, it should be enforceable, period. That's my opinion. If you didn't want to live in a community with those restrictions, you had that option. You chose not to do it. You bought into a community that had restrictions. If you don't want to comply with them, move out, sell. I don't care. But don't tell me that the association that's had these restrictions in place for 50 years should now suddenly be told, yeah, let's forget about all that. Just doesn't make sense to me.
Hey, Bender Rimbaum. Great show tonight. You can call. This is the number. It's good for any of the offices, 800-974-0680. You can go to www.kbrlegal.com. We're going to be back again with you Thursday night at 6 o'clock. 5 o'clock. And we will have Alan again. Alan, you make the show go by so fast.
I think that's mostly you, but I appreciate it, Steve.
Okay. Yeah. Anyway, thanks so much, Alan. Alan Swartzside, he is with K. Bender Rimbaum. He's a big guy now. Board certified. Congratulations.
Thank you. Much appreciated, Steve.
And we'll be back with you next week with more Ask the Experts. Thank you, Rebel. Thanks for all the people who wrote in, who's been sending in these letters, these great questions. We'll be back again Thursday night, 5 o'clock.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.